who expects to be a witness for either side in this case, please stand, raise your right hand, and be sworn if you expect to testify in this case. It's better to kind of shift away so I can see them. You swear or affirm the testimony you'll give here today will be the truth and the whole truth under penalty of law. All right, the three of you need to go out in the hall. Do not discuss this case while you are waiting. We will call you if and when you are needed as a witness. Thank you.
And Your Honor, we have one other witness that went down. No, she's here. She just went downstairs for a moment.
I can swear that person in.
Okay. Let me tell our other witness to just tell her
Tell
not
her
to
to
step
wait
down.
out with the others, and then you just let me know which one needs to be sworn
Thank you.
when she's called. Any preliminary matters that need to be addressed before we start the trial on the permanent protective order?
Well, yes, Your Honor. Your Honor, I did file the motion that we talked about last time with respect to the First Amendment. There's also an issue with the protective order. I touched upon it in the motion, and that is that the protective order is actually brought or actually issued by the judge checking off a box that it was because of a crime of violence, force, or threat. Now, there never was a crime of violence, force, or threat. The legal standard for finding the protective order, however, and I think this is probably true regardless of which box the judge checks, is there a preponderance of evidence, their burden, of violence, force, or threat? And I would ask the court, before we move forward, just possibly in lieu of opening statements, if the parties aren't doing statements, can they make a proffer of any violence, force, or threat?
Well, that matter was heard, wasn't it?
The protective order?
Yeah, by ex parte. Wasn't that an ex parte?
There was a ex parte motion. It was heard. It was Judge Daniel. She checked the box, not that there was any violence, force, or threat, but she checked the box that there was a criminal warrant issued for a crime of violence, force, or threat. Well, now that warrant, any warrant has been dismissed, and I would argue that warrant was never a warrant. If you look at the definition of 19.2, 152.7:1, it defines what a crime of violence, force, or threat, which crimes are allowed, and they have to be a crime of violence, force, or threat. And that starts with the first protective order issued. And this goes to the foundation of the protective order.
Mr. Griffin, you want to be heard on that?
Sure. I have the first protective order in front of me, and it says that what the judge's handwriting says. I agree with counsel. She checked a box. Petitioner indicates a pattern of direct and indirect communications intended to put her in fear and to intimidate her using phrases such as, quote, take out, and using references to firearms. Very concerned for her safety and that of her children. And then the court made certain orders that the respondent shall commit no acts of violence, force, or threat or criminal offenses that may result in injury to personal property. There were no exceptions of any contact, and it required her to stay 500 feet away from the petitioner's residence, not make any social media posts, comments, etc. regarding the petitioner or her family members.
Well, I mean, that's a summary of every part of the protective order except what we are talking about. We're talking about court fines, and you look at paragraph 1, the box is checked, a warrant or petition has been issued.
But the court can correct an error.
Yeah, I don't know that it is an error. I guess the question that...
It was a warrant, it just wasn't a warrant of violence.
Yeah. Our point, and if we just want to move forward with the evidence, is there is no threat, there is no violence, there is no force. They've not alleged anything in any of the paperwork leading up to this, and I don't think that they can even articulate those three things. And in the purpose of time, moving forward with this, they should be able to at least articulate what the force is, what the violence is, what the threat is.
But regardless of the ruling on that motion, Mr. Basler, the court could still consider a permanent protective order even with the denial of a preliminary protective.
I agree.
And so it may be that this matter is going to be heard on a permanent protective order anyway.
Okay. My other motion, I respect the court's ruling. My other motion goes to the First Amendment motion I filed, that this protective order is void ab initio because it is a prior unconstitutional restraint on speech and therefore has a chilling effect on all speech. And because of the special protection given to First Amendment issues, the protective order is simply overbroad and should be dismissed on its face. It requires something the law does not allow. If you look at the protective order statute, what the judge can do, there's 4 items enumerated. And this exceeds the statutory authority. And putting the statutory authority aside, it exceeds, even if the statute allowed this, it exceeds the protection afforded Ms. Scarborough with the First Amendment of the Constitution, and therefore cannot stand.
Griffin, you want to be heard on that?
Judge, I'm glad that counsel noted that there are not only one reason that a protective order could issue, but up to 4. It does say that the court can prohibit contacts between the parties as the court deems necessary for health or safety, and any other relief necessary to prevent any acts of violence, force, or threat, criminal offenses, which we heard 2 weeks ago, or communication or any other of any kind by the respondent. That's what the statute says. So if I understand Mr. Basler correctly, he's arguing that 19.2.152, the protective order statute in its entirety, is null and void because of the First Amendment. And I'm not seeing any court case that says that in Virginia or any other place in the country, and almost all 50 states have protective order statutes that are similar in nature to the one here in Virginia. So unless Mr. Basler has a case showing that that provision is unlawful, I think we just proceed under the statute.
Yes, Your Honor, he's misstating the statute. The statute reads, and we're talking about 19.2.152.9 paragraph A, and it has 4 subparagraphs. When Mr. Griffin cites the language any kind, it reads such other conditions as the court deems necessary to prevent communication or other contact of any kind by the respondent. And that reads contact by the respondent with the petitioner. That's not what we have. We don't have communication to the petitioner. That's prohibited. Okay, that is prohibited, but not just that. That's not the constitutional problem. The constitutional problem is
What does it say, petitioner in paragraph?
well, it doesn't say petitioner, but it would make no sense to read it any other way. Otherwise, it's communication or any contact of any kind by the respondent. If you read it that broadly, Your Honor, you can stop her from saying anything at any time. You could stop her from going to school, participating in discussions in class. It would be incredibly overbroad. And if it's that overbroad, the statute can't stand. But I'm not saying that this protective order statute is unconstitutionally overbroad. It can be read to be a reasonable statute. To read it that way, it has to be communication. It has to be provisions to prevent communication or contact by the respondent towards the petitioner, not just about the petitioner. And that's where you get to the overbroadness of the ruling.
Well, on the issue of constitutionality, the court finds that the statute allows in fact, empowers the court to prohibit communication or other contact of any kind. And it doesn't limit that in any way. And it's not the province of the district court to rule on constitutionality. It's to apply the law. But by the same token, the statute in Virginia allows the court to have that authority. And that's what the judge did. in the preliminary protective order, so your motion's denied.
Understood.
There may be another court, another ruling that could bestow your constitutional argument, but not the district court. The court's not going to make any change to the statute on protected persons. All right? As to your argument on the warrant box being checked, may or may not be a curable error. In any event, even if the protective order were denied, if it wasn't, a hearing could still be set on a permanent protective order. And so I'm going to allow the hearing to go forward on a permanent protective order. They would obviously have to meet the requirements of 19.2, 152.10 on that. Okay?
Thank you, Your Honor.
That's where we are on those issues. Depending on the final ruling on this order, I'll consider your component of your argument pertaining to the warrant.
Yes, Your Honor.
The warrant box. Okay? All right.
Judge, the only other preliminary
Yes, sir.
matters,
If anybody wants to make an opening statement, you certainly can.
well, let me go through these things real quick. Number one, I'm going to presume that the court's going to incorporate all the testimony we heard 2 weeks ago so that we don't need to duplicate that. I know that that was essentially all with the quote-unquote criminal case with Kristen, but we think the court ought to go ahead and incorporate the prior testimony.
Well, I'm treating it like we are just continuing on
Yes, sir.
as if we'd done it that same day.
I just want to make sure.
We didn't do it that same day for judicial expedience.
Yes, sir. And then the same with regard to the exhibit. There were 8 exhibits that were introduced by the Commonwealth. We just want to make sure that those 1 through 8 are also incorporated so that...
Well, I do object, because I would like, there were issues of relevance of all those documents that are issues in this case that weren't in the criminal case.
Well, that's true.
And
I think you're going to have to, they've all been marked for identification, and while they came into the criminal case, they may not necessarily have evidentiary value in this case.
And that's my argument. None of them are relevant.
Okay, well, you may be right.
Well,
I don't know, but I'll let you.
Thank you.
Let you argue each
Yes, Your Honor.
exhibit if he wants to make reference to those exhibits. He's got to introduce them again.
Yes, Your Honor.
Because it is a different proceeding.
Well, I was trying to avoid having to introduce exhibits 1 through 8 and to go through that process again.
But this is a civil case, a different proceeding with different standards, and he's got a right to have that flavor of the argument addressed.
Well, and I think there are 2 issues. Number one is the preponderance of evidence is a lesser standard in the civil case than the criminal case. And number 2, one of the issues that the court needs to look at is whether there's been a repeated course of conduct. And we're trying not to go back and spend what I would guesstimate would take us 2 hours to go back and redo exhibits 1 through 8 when they've already been introduced in what I understood to be sort of a simultaneous hearing that when the shot clock ran out, we decided to move it over to today.
There were never simultaneous hearings. They were successive hearings.
Okay.
And I'm treating them as successive hearings. The more that can be done by agreement that could make that more convenient, the court's fine with that. But if he's got a right in a separate case
I understand.
to raise any legitimate objection, he's got.
And Your Honor, with respect to the authentication that was ruled on, with respect to the foundation, I don't have any objection to that.
Right.
I just want to be able to say that this is not relevant because this,
No, I think that's right. I think that's true.
because a pattern of conduct is not something that's required in a protective order. In fact, it has nothing to do with this case. It's violence, force, or threat. Thank you, Your Honor.
Okay, well, my ruling isn't altered by any of that, and I will allow argument on exhibits. They have to be introduced, and if there is no objection, that's fine. If there is an objection, by either party. You have a right to be heard in this proceeding as a separate trial.
Okay.
Okay? Any further opening remarks for the good of the order here?
So just so I'm understanding correctly, the prior witness testimony is going to be accepted without having to reduplicate it, just the witnesses, the exhibits we would have to reintroduce.
Well, and also the relevance of the witness testimony, too. There has been, the problem I have, and I don't mean to keep repeating myself, is there have been no evidence of any violence,
I don't know that
force, or
I've
threat.
ever had much of a problem repeating.
And there has been nothing admitted, Your Honor, that is relevant to this proceeding. That is my argument, Your Honor.
I think either counsel on a separate trial has the right to hold the court and the other counsel's feet to the fire on doing it right. And this is a separate trial. It's the idea was that we would be able to incorporate a lot of this and not have to duplicate. And maybe there's a way to expedite it, but either party certainly has the right to require that the foundation be established, and that witnesses be called and tell their story that plugs into this civil claim. And so they have a right to do that. Obviously, the board that's agreed on, the court is certainly not upset about letting those things in if the parties agree to them, but you don't have to agree. And if you don't agree, then we're trying the case, and he's got to prove his case by preponderance of the evidence, and you've got all your rights to object, and he's got all his rights to object on anything you want to do. Okay?
Yes, Your Honor.
Are we squared away on that?
I think so, Judge.
Okay.
Judge, we'd go ahead and call Ms. Bellido to the
All
stand.
right, Ms. Bellido, come forward to the witness stand, which is up here to your left. And I'll swear you in when you get up there. You can go ahead and be seated and just raise your right hand for me.
If it's all right with you, I'm going to ask some legal questions.
All right, I'll stop when I'll stop when it gets.
Yes, sir.
Answer Mr. Griffin's questions, and then Mr. Basler may also have questions.
Ms. Bellido, can you state your full legal name for the court, please?
Priscilla Bellido
And where you live?
in Frederick County.
Okay, and what's your address? Okay, and does anybody else live with you?
Yes, sir.
And who is that?
My husband and my two small children.
Okay. And are they school age?
Our eldest is.
You previously testified about 2 weeks ago in a case in a courtroom across the hallway. Do you recall that?
Yes, sir.
And is the testimony that you gave 2 weeks ago, is that still true and accurate to the best of your knowledge?
Yes, sir.
And just the same objection I've made.
I understand.
There's been no evidence of what's required by the statute.
Well,
She's
there is no transcript of what she testified to before, so the court has its notes on what she testified to before. But notes are just the court's recollection of certain things. I think in regard to your objection, I think she's adopting her testimony from the prior hearing, which Mr. Griffin may have to flesh out. So
We'll do that. And Judge, at some point we will need exhibits 1 through 8, which the court has in the file from the criminal case. Ms. Bellido, do you know Christine Scarborough?
Yes, sir.
And where is she?
The defendant here.
Okay, and where is she seated and what's she wearing?
Next to Mr. Basler, blue sweater.
Okay, and how long have you known her approximately?
I believe since around the beginning of November last year.
2021?
Yes, sir.
Okay. And did there come a point in time where you and Ms. Scarborough talked about the mask mandate issue in the Frederick County school system?
She became a co-plaintiff.
Okay.
On the motion for temporary injunction, that was filed.
And when and where was that filed?
February 2nd, and it was filed here in Frederick County.
In Frederick County Circuit Court?
Yes.
You all were both parties on the same document.
Yes, sir.
Is it fair to say that that lawsuit was relatively successful as far as the purposes being accomplished?
Objection.
Yeah, that's
I'll-
a legal conclusion.
Fair enough.
Objection sustained.
Is it fair to say that at some point in time, Ms. Scarborough withdrew her name from that case, to
Yes,
the
sir.
best of your knowledge?
Yes, sir.
And did you all then have a falling out of sorts after that?
I don't know what you mean by falling out.
Okay. Had you had her over to your house back in, say, January, February, early March of 2022?
Early February, yes, sir.
Okay. At some point in time, did Ms. Scarborough, did she go by another name on Facebook or social media, to your knowledge?
To my knowledge, yes.
Okay.
I have a few.
Well, objection, I guess it goes to what her knowledge is. And I'm not sure what count they're talking about.
I think you'd have to lay a foundation for her knowledge. Objection sustained.
Did you and Ms. Scarborough have discussions about whether she had any social media accounts?
Yes, sir.
And was one of them, if it's okay with the court and counsel, I will lead until there is an objection
Fine.
so that we can sort of expedite the process. Did you all have discussions about whether she had a Twitter page?
Discussions about Twitter page?
Yes, ma'am.
No, sir.
Did she indicate to you that she ever was using Tyrant Hunter as a Twitter account that she had?
No, she did not indicate that directly to me.
Was there information that was placed on that Twitter page that would indicate that it was coming from her?
Yes, sir.
And what types of information was that?
Screenshots of some documents that were served only to her
Okay,
back in March.
okay. And what were those documents?
The first one was a no trespass.
I'm going to object. It's not relevant, Your Honor. I mean, are we going to go through everything that went back and forth on social media? I mean, why bury the lead? It's violence, force, or threat. It's clearly laid out in the statute. Why aren't we talking
Well, I
about
think he's
that?
laying a foundation for information that may pertain to that of how she had access to it. And for that purpose, I would allow it for her to say how she got this information consensually, if that's how she acquired it. I think that's a necessitous component of what may have led to threats or fear or danger or safety. And so laying a foundation of how she was getting this information consensually would be permitted. I'll allow that. But whether the information goes beyond just laying a foundation, then it's got to live or die on its own connectivity to the case.
Thank you, Your Honor.
And was some of this information that you provided just to her, was some of that posted on a Twitter account?
It was information that was just provided to her.
Okay. And was that the Tyrant Hunter Twitter account?
Yes, sir.
And you believe that to be Christine Scarborough?
Yes, sir.
That's the exhibit one from the other case the other day. Now, you indicated that you had
It's not relevant.
Judge, we're going to move to introduce the information on Twitter about the cease and desist letter
And
that
we're
was Commonwealth's won the other day.
And we object. It's not relevant. I mean, the fact that there was a cease and desist letter, the fact it was published online is not relevant for the question of a protective order. I mean, these protective
Where
orders...
does it fit into a threat of
Well,
violence?
I think you're getting there. I think what we're trying to do is establish a pattern of what Ms. Bellido did, all the steps that she took before it was necessary for her to get a protective order, where the judge says there's a pattern of direct and indirect communications that in her finding.
I will stipulate, she sent a cease and desist order to Ms. Scarborough. She had her served with a no trespassing order. Those two things were in evidence in the last case, and I will stipulate that that happened, but it's not relevant. I'm not stipulating to the relevancy, and it doesn't lead to a threat. They don't have evidence of a threat. We're building to nothing, and they're doing.
I'll allow the stipulation that the cease and desist letter was sent.
Thank you.
And you're also stipulating that who doesn't trespass.
Yes, that happened.
Right.
That happened.
If I can, I'm going to return the preliminary protective order to the court that was attached to the exhibits. That's 7 and 8, the trespass notice and the protection.
Yeah, go ahead. And Your Honor, the 7 and 8 are the trespass notice and the cease and desist, and I'm sure the court remembers them from the last hearing, and that happened.
Through the sheriff's department.
That happened.
Okay?
It's just I don't see why they bear on this case, but just to move things along, ask the court to consider
I'm going
those.
to leave them marked as 7 and 8, even though there's no
Yes, Your Honor.
in this case, but- Okay? All right. So admitted, Mr. Griffin.
Thank you, Judge. Were the trespass notice and the cease and desist letter later published without your permission on any social media accounts?
Objection. Not relevant.
Why is it relevant?
I think it comes in. I think it comes in as a form of cyber harassment to publish personal information.
There's
I think it gets to, we're headed towards the threats
Well,
and the
the court's
issues.
ruling in the criminal case, as a matter of law, was that the trespass notice and the cease and desist notice were served through the sheriff's department, which made them public records.
The court did make that ruling.
yes.
Then I think they don't have a special protection within this proceeding other than what they are. So, I mean, she can't turn something over to the sheriff's office and say, take care of serving this, which they have to have a record of serving it, then that becomes a public record. And then say, I complain because she's putting that online. It's already a matter of public record.
Well, I don't know that all of it's on public record. I think that the sheriff, when they intake some of this stuff, they redact some of the information that is available to the public. So they do serve it on the individual, but I don't think that they, in their internal records, have all of that information. If they had date of birth, social security number, address information.
I'll receive those exhibits as stipulated, because that's what they did. His objection is that it's not relevant to the case that she posted up.
That Christine Scarborough posted.
Right.
And I disagree with that. I think it's relevant to the case because it occurred earlier in time than the request for a protective order.
And Your Honor, our objection again is relevance. And if he can say how this connects the dots to a threat, then I think that might change the admissibility issue. But he would have to be able to articulate that. And I think he'd have to be able to articulate what threat are we talking about.
Well, that's Mr. Griffin, that's the problem I
Right.
have with it. She's merely posting something she got through the sheriff's office. Really, it wasn't from her, it was from the sheriff's office. I think she has a right to do that. And so how does that become a threat in and of itself? I don't think it does.
I think it goes to the repeated course of conduct online through various social media forms of harassment towards this individual, where she is in a reasonable position where she fears that she's going to be harmed, and we're laying the initial, there's other stuff that we can get in,
Well,
but we're trying to lay the original foundation.
I'm going to sustain your objection.
Did there come a point in time where Ms. Scarborough contacted you by text or email in early March that you were concerned when she called you names?
Yes, sir.
And what types of names did she call you, and approximately when did that occur?
It was early March via text messages.
Okay.
The names.
I'm going to object relevance. Again, it's not a threat. Calling somebody names, I mean, they're making a farce of the protective order statute. The protective order is a very narrow remedy. And they're not touching upon what the statute says is required for a protective order. People do all kinds of things online, call people names.
Okay, but at this juncture, the names could be inflammatory or fighting words or
Correct.
something like that. And so at this juncture, I'm going to overrule your objection.
What were the names that she called you?
It was via text message.
Okay.
And it was within other sentences, but the names themselves were fucking dumbass, you fucking idiot.
And what was your reaction when you
And,
got
and the
these?
same objection, relevance.
I'm not going to give that a lot of weight, Mr. Basler, but I will accept it for where it may go if it gets any worse than that.
Yes, Your Honor.
That in itself would fail a sufficient
That's correct.
allegation. But I will give that limited weight
Yes, sir.
depending on what else we hear.
And did there come a point in time where she accused you of any, what you believe to be criminal activity?
Yes, sir.
And what did she accuse you of doing?
Objection, relevance. I mean, that's not a basis for the protective order accusing somebody of committing a crime. I mean, there are other remedies for that. You can sue somebody for libel, you can sue them for slander. There are a legion of remedies. This remedy is for someone that is subjected to violence, force, or threat. So it's not relevant to this case, Your Honor.
And I understand that Mr. Bassler keeps saying that, but the statute has more than the violence, force, or threat requirement, that there are 4 different requirements that could be met, including if Ms. Scarborough did it willfully, she did it repeatedly in the course of conduct, and if it causes harm to Ms. Bellido.
I think we need to look at the statute because what he is citing is not the protective order statute.
I've got the statute. I've got the protective order statute.
It says-
But in this case, she did get a criminal warning.
Mhm.
So I'm going to allow the question. Once again, the weight may be relatively modest, but I will allow the question. If she did get a criminal warning, yes.
May I just, Your Honor, I just want to make sure I'm not missing something. What statute is Mr. Griffin citing that he says that there are these 4 things?
I've been looking at 19.2, 152.10, effective as of January of this year.
Your Honor, the statute, the actual standard is 19.2, 152.9, paragraph D. He's looking at the remedies once the court finds a protective order. Okay, what the court can do once the court finds the protective order. But 19.2, 152.9D, very short paragraph, it says, at a full hearing, the court may issue a protective order pursuant to 19.2, 152.10, okay, those are the conditions. If the court finds that the petitioner has proven the allegation that the petitioner is or has been within a reasonable period of time subjected to an act of violence, force, or threat by a preponderance of the evidence. That's the gate. You got to open that gate before you get to 152.10. And maybe that's the difference of understanding on this. That is the legal standard for the protective order. And that's why I do keep repeating myself, because he has not introduced any evidence up to this point that meets that. We're going through just a relationship that broke down. And we could do that with a lot of people. A lot of people feud. A lot of people say nasty stuff. And nowadays, they do it online. So we could have this hearing for probably 30% of the public. And that's not what this statute is about. It is an exceptional remedy. And it needs, the evidence needs to meet the statute. And that's, I'm not trying to be difficult, but that's the law.
matters that the court has allowed in evidence up to this point have to lead to those quotes.
And I agree. The court's ruling so far, I take no exception with.
And I'm inclined, Mr. Cavazler, to agree if there's got to be some correlation. We're letting these soft issue items come in, name calling and posting of no trespassing notices and cease and desist. But even in conjunction, those don't add up to fear or force, violence, or threat. So it's got to be tied in on the testimony, and the exhibits have got to plug in to 19.2-152.9. 10 is the protective order, what the
That's
court
what the order
will
would
do
say, right.
based on this hearing.
Correct.
Okay,
Thank you, Your Honor.
sustained.
Okay. The statements that she made to you were March the 9th, is that right? Using the F-bomb.
Yes, sir.
You sent the trespass notice March the 14th. Was there anything else that happened between March the 9th and March the 14th that you recall?
On the same day that the text messages were sent to me, a acquaintance or friend of Miss Scarborough's came to my home,
Okay. Invited, uninvited?
uninvited.
Okay.
I did go to the new female magistrate, but she was, she questioned me, asked me if I had been physically harmed yet.
Okay.
I told her no, so it was a in and out process
Okay.
at that point.
Did you contact the Frederick County Sheriff's Department, say in March or April, other than to have them serve the trespass notice and the cease and desist letter?
I did multiple times.
About how many times do you think you contacted them?
Maybe 4.
Okay, and were
Three or four.
all of those contacts related to concerns about Christina Scarborough's behavior?
Yes, sir.
Objection. Relevance.
Well, that's the next question.
Well, as a foundation of what those complaints were, then I will allow an objection overruled.
What were the things that you contacted the Frederick County Sheriff's Department about after March the 9th?
Well, the text messages, we had never had any kind of exchange, even similar to that. So it was a very long text message with the aforementioned
Okay.
things in it, and I contacted them about that.
Okay.
And let them know that I was concerned because
Objection to the fact she's concerned.
I'm going to allow that. She is explaining what she's doing and why she's doing it, and using a term that has a pretty recognizable common definition.
Understood, Your Honor.
I'm going to allow that. Objection overruled.
Go ahead.
I was concerned because we had never had any even similar type of conversation, and it was the text messages were conveyed to me, with all capital letters and things. So I told them that I was concerned because she was obviously, in my opinion, mad and upset. And
Objection to her opinion, but for what it's worth.
I'll treat it as her assessment or a description of that communication as bad or upset. I'll allow that. Objection overruled.
And approximately when was the next time that you contacted the Sheriff's Department, and why?
The things that we've discussed previously, the various social media postings regarding me and the temporary motion for injunction, those postings were pretty much every day and were brought to my attention by various community members.
Okay. And what were the things in those postings that Christina said that concerned you enough to contact the Frederick County Sheriff's Department?
There was one posting that had that said that I identify as a threat. There was
Objection, lack of foundation. We don't know where this one's from.
Yeah, I'm not gonna rule yet, but I'm gonna instruct counsel that you have to get who's being threatened. And
We've got it.
bring it.
We'll get there.
Okay, well, let's get there.
Okay. What, and is that on the Tyrant Hunter page? That's your copy. You got yours? Okay. Is this the Twitter post that Ms. Scarborough made that you reported to the Sheriff's Department?
This is one of them that
Okay.
I was concerned
Okay.
about.
Well, I'm, again, I know the court's earlier ruling, but I'm going to object to her concern. There is no evidence that this was sent to her, mentioned her, had anything to do with her. I mean, really, it's talks about being a meme. I identify as a threat. My pronouns are try/me. Why does that have anything to do with this case? I mean, it's something done in humor.
I don't know.
Well,
So
I edified.
I will certainly ask.
All right, I'm going to sustain your objection, but I'll
Sure.
leave the door open to pursue what this threat is and how it is applicable to our factual situation.
This Twitter post I identify as a threat was says it's around April. Is that April 4, 2022? Is that right down at the bottom, the date?
Yes, sir.
And what was going on with you and Ms. Scarborough around early April of 2022 that you believe this was directed towards you?
I'm going to object. That's a compound
It
question,
is a
one that
compound
she
question.
believes that it was directed to her. I object to that.
I'll
That's just
with-
her subjective belief.
I'll withdraw the compound question and break it up.
Check.
What was going on with you and Christine Scarborough in early April 2022?
Well, up until this point, as I previously mentioned, just about every day on this particular social media profile, almost every day there was a post regarding me, regarding the aforementioned temporary injunction.
I'm going to object under the best evidence rule. If these posts, the best evidence of them is the posts themselves, if this is every day.
You have some questions?
These are the same exhibits that Mr. Bassler previously objected to. So we'll go ahead and introduce them.
I think you should have to do them one by one if he's tying those posts somehow to this post.
I do them one by one.
Fair enough.
These don't have any dates. They don't have any dates.
I understand. What's previously been marked as Commonwealth's Exhibit Number 1, this is the Tyrant Hunter, and this is the account that you believe is Christine Scarborough's, is that correct?
Yes, sir.
This is the one where she mentioned the cease and desist letter just several days before the identify as a threat.
Well, objection. He's definitely leading her on that. There's no dates on that, and that's not in evidence before, not in the last hearing, not now, that it was several days before that.
Well, we just stipulated that on March the 17th, shortly thereafter, she received as exhibit number 8 a cease and desist letter, which she received shortly after she got the no trespass
But
notice.
his objection is that you're telling her the answer to these questions, and what you need to do is ask her to identify
right.
the situation, not tell her what the situation is.
Yes, sir.
Just to stay.
Are those messages from Christine Scarborough's account on Twitter?
Yes, sir.
Okay. Judge, we would move to introduce those to lay the foundation that that's her account.
The foundation will require some time frame.
Yeah, I think we have to know what the time frame is.
Okay. And when was the cease and desist letter sent, approximately?
Approximately, it was on March 14th.
How about if I get the, we can get exhibit 7 and 8, Judge, that we just handed up previously. Now approach the witness.
Yes, sir. Either counsel may approach witnesses with documents to identify.
What's the date on the letter?
This is the cease and desist,
Okay.
and it was March 17th.
And about when was she served, to the best of your knowledge?
March 17th.
Well, my objection is the time frame on those Twitter posts.
And
Well,
these,
I presume he's setting this, reminding the court of these
Correct.
dates, and now we'll get to that. So
correct.
we may-
So when were the Twitter posts referencing the cease and desist letter in relation to when she was served, to the best of your knowledge?
They were just within a few days after the sheriff's department served those documents.
Okay. And is it fair to say that those posts would have been a couple days before this post?
Objection. That's leading, and it's totally inconsistent with what she said. We got March 17th, a couple of days, and then April 4th, which is 2 weeks later. And he's trying to spoon feed her something that's not even true.
Yeah, you are leading here, Mr. Griffin, notwithstanding the ruling of the court.
Yes, sir.
The court sustains this objection. She's got to identify these things independently of your instructions,
Okay.
other than telling her to identify it.
We would go ahead and move to introduce exhibit number 1. I think she's properly identified it at this point. I understand counsel's objection to.
Yeah, my objection is that's not relevant. I mean, I thought he was doing it to tie it to this. It doesn't tie it to this intended exhibit, which I object that that's not relevant. But one thing at a time. What he's introducing now, those Twitter posts, not relevant. We already have the courts. The court has knowledge that the cease and desist letter was filed or posted, that it was posted, that the trespass notice was posted.
Are these communications from the defendant, from the respondent?
Those are posts, and that's really the issue with this also is they're not. This is not just Miss Bellido in this world. These things are posted for many people to see, and to look at something and just believe, oh, this is all about me is really hubris, okay? Because people post all kinds of things online for just humor. And this is clearly in jest. I identify as a threat. My pronouns are try/me. It's an allusion to the gender politics of today, and is not relevant. They're trying to shoehorn it because they have nothing. They're grasping at total straws and making
Identify who posted that. This item that you're seeking to report consider. Do you know who posted it?
The Tyrant Hunter profile,
And
previously.
who is that?
That would be Miss Scarborough, because my name she uses previously in her post, and says, "Go ahead and sue me, come and get me." And she says that she just got one from Priscilla. There were so many posts, multiple posts even on several days that, you know, when I couldn't go back and get the dates of the posts because this particular social media account is now defunct. So there were multiple posts on this particular social media account that that called me by name in the post.
All right, well, we're dealing with this one. I'm going to allow it over the objection for whatever it may represent, but it doesn't look like it looks pretty general and pretty broad. But I'll accept it over the objection.
Yes, sir.
Whatever number's on that one. Is there a number on it?
Commonwealth 1, I believe.
One, okay, we'll just call that one. It's the third exhibit that we recorded.
Yes, sir.
Over the objection, though.
Let me make sure we got,
Responded.
that's number 1, and then the one that says identify as a threat. I was going to suggest the court mark it as number 9 rather than number 3 to use the numbering system from last time.
Well, okay,
And maybe I'm jumping the gun on
well, I think
what's coming
you're
in.
jumping the gun. I object to this as one not relevant. There's no evidence it's
Well, I haven't
directed.
ruled on
Yeah.
that one
Okay,
yet.
so we're doing exhibit number 1.
And
Right.
exhibit 1, I understand
Gotcha.
the court has let that in, and-
Okay.
Yeah.
and we respect
Well,
that
we haven't
ruling.
crossed that bridge yet.
Sounds good.
Next exhibit.
Okay.
Let me have one there. Thank you.
Were there other posts between this one in March that were placed in a Dropbox between that date and in April or May of this year?
Yes, sir.
I'm going to show you what was previously listed as exhibit number 5 first. That was the exhibit from 2 weeks ago. Are those additional pictures of posts from this tyrant hunter after the cease and desist letter?
Yes, sir.
Is there anything in there that specifically references you?
Yes, sir.
And what is that?
My name in the commentary.
What does it say?
Priscilla must be tripping out. The level of triggered is through the roof. What a weak woman. Save the video now, folks, before it's gone. And repost yourself if you'd like. Or send me a message and I'll send it to you directly.
Okay. What's next?
An objection to the relevance of that.
I'm going to allow it. It may not help the case very much. But
I mean, they're alluding in there to a video that, of course, you can't watch on a sheet of paper. And this is
Okay.
where you get into best evidence problems with just introducing the
to
paper.
the extent that it pertains to the video, which we don't have, I would sustain that objection. But I'll allow whatever has been presented as something that concerned her. I'll allow it,
Yes, sir.
giving it appropriate weight.
The next one is
Yes, ma'am.
careful. Priscilla likes to report videos. She can only dish it. She can't take it. And it was just an attached screenshot that I guess she had received on her other social media platform, the YouTube, which says that it was reported as violating privacy conditions.
Objection, relevance.
For the same reason, I'm going to allow it. These are offered to show that she's getting more and more upset by the frequency of these messages, and she thinks they're targeted at her. But whether that is sufficient for the statute is a different question. But for the purposes of her presentation, I'm going to allow over your objection.
Yes, sir.
Keep going.
Another one, it says, I'll be uploading more into this Dropbox as time goes on, but since we have a delicate snowflake hell-bent on taking down my post, this is a necessary step. I am starting a Dropbox that will be public, and I will put out all the info, screenshots, and videos that Priscilla wants to be taken off the internet. Good luck censoring and reporting that.
And approximately when was that stated?
That was around the end of May.
Okay. Is that right around the time that you asked for the protective order?
Yes, sir.
Okay. And what else is the last part?
The same objection, and I understand the court's ruling.
Okay, objection overruled.
The next one.
Yes, ma'am.
There was a video that was posted that, of course, like you said, it's paper, you can't see the video, of course. But it was like a movie clip of a lady that was really angry, cursing out like another lady. And then immediately beneath that, a posting, Betcha P wishes she didn't report my post. All she did was piss me off, not shut me up. I barely scratched the surface, sweetie. I'm putting a smile on my face and your crap on blast.
Okay. Judge, we'd move to introduce exhibit number 5. Collectively, it's the same.
Just
I understand
relevance
counsel's
objection.
Over your objection, court will nip those, giving them such weight as they will require under the statute.
After these items came out on Twitter, did you contact the Frederick County Sheriff's Department again?
Yes, I believe so.
Okay. And what steps, if any, did you take after that?
I called the Commonwealth Attorney's Office to explain what was going on and see what the options were. I also called the magistrate's office. I had already been to the magistrate's office, but I'm not real familiar with how the whole process works. So one of the options that was
Objection, hearsay.
Sustained.
Yeah. Can't say what they told you to do. What did you do after you called them?
Oh, then I came here to this courthouse,
Okay.
the clerk's office downstairs, and explained what was going on, and
Was it at that time that you saw the protective order?
yes.
Okay. The Dropbox, the court probably reviewed about 40 pages from the Dropbox last time. Was there anything, I'm going to give this to you, is there anything specific in there that you recall or believe to be a threat of violence, force, or a threat? And I will proffer, I don't want to tell you what to look at, but...
Then why don't you be quiet, just let her.
All right.
All of the things that were put into the Dropbox, including like previous photos of me from
Okay.
like 15, 16 years ago at former workplaces. Those things were looked up or whatever and put into that Dropbox.
Well, the objection not responsive to the question. The question was about violence, force, or threat.
Yeah, you have to hone that in, how it plugs into violence, force, or threat.
In other words, what I want you to do is to look at the Dropbox and see if there's anything specifically from Christina to you. I think we previously established that there was a lot of stuff put in there.
I immediately became concerned because of the aforementioned cease and desist letter and the thing, being served.
Objection not responsive.
Well, I'm going to allow that testimony as if she's asked by formal service of process that the respondent stop doing this, and they're still coming. And I think she has a right to say what her concerns were about that, and which I think is what she's getting ready to say or has said. So I'm going to allow that objection overruled.
All right. Keep looking through the paperwork.
So my immediate concern was that document with my home address on it.
Right. And that's the one we had the hearing on last time.
Yes, sir.
Okay. Keep looking through to make sure that there isn't anything else. Okay. Whoops, sorry. I thought you were finished. Sorry.
As I previously mentioned, the the research, my previous workplace photos. It was 15 years ago or so.
Okay.
So those things.
Did the Dropbox contain any?
Objection to leading. He's already asked the question.
I'll wait till she finishes it, then I'll ask additional questions.
All right, well, ask her when she's ready to respond.
Yes, sir.
Another document that had my private email on it, in conjunction with the document that had my home address on it. And that was an immediate concern for me.
Okay.
There were some screenshots of previous postings concerning the motion for temporary injunction and an account that I set up for people that were asking to donate
Okay.
money towards that. So there were some postings concerning that, which really concerned me because Ms. Scarborough had already.
Objection not responsive.
Sustained.
Yeah, just to stick with that stuff. We'll come back and we'll.
The previous conversations that I had with various people that didn't even include Ms. Scarborough.
Those were items that were posted in this Dropbox.
Yes, sir.
Was the drop? Go ahead. I'll let you finish before I.
An email that was actually that was sent to me by you. That email was posted in this Dropbox as well. Another email that was an email exchange between your your legal secretary and I. That was posted in that Dropbox as well. The no trespass notice that we previously mentioned.
Was also posted in the Dropbox?
Yes, sir.
Okay.
Again, with my home address, that was a concern. And then also some screenshots of postings of my business account, my business social media account. That is a private account that Ms. Scarborough was not part of.
Okay. Judge, and for the court and counsel's benefit, I don't believe we intend on introducing exhibits 2, 3, 4, or 6 at this time. I just want to make sure that you went through everything. Did she make any accusations in some of these social media posts about you committing crimes that you're aware of?
Objection. Authentication. Best evidence.
I would sustain that objection.
And did she post any photographs of your family that you were concerned about?
Yes, sir.
And what did she post?
There was,
Objection. Best evidence and authentication.
I think if these are disconcerting enough to be of evidentiary value, then the best evidence will apply.
Okay.
Sustain the objection unless you have something.
The items in the Dropbox, were they available to the public?
yes, sir.
Were there any limitations?
No, I don't believe so, sir.
Okay. And were the items in the Dropbox posted, when did you find out about it?
I viewed the Dropbox and the associated documents on May 26th.
Okay. And that would have been after this, they identify as a threat.
Yes, sir.
Judge, we would, do you believe that this post I identify as a threat was directed toward you?
Objection to what she believes. They have not connected the dots to that. And, Your Honor, it is really on its face just
I'll
a
sustain
jest.
the objection. I think you just need to ask her why she feels this was something she needs to have the court address with a protective order, that exhibit.
There you go. Why do you think that the court needs to take a look at this as part of your protective order case?
Well, when this particular social media account was brought to my attention, as I previously mentioned, every single post, even multiple posts a day on Sundays, were directed at me. Either by name, by utilizing my name in the post, the cease and desist that we previously mentioned, the no trespass. There were multiple. I don't even know how many. As I mentioned, many were posted per day, some days. So everything was directed at me.
Was there anybody else that she was posting this volume of information about or making these comments about, say, late March to early April?
On this
account?
On this particular account, I never saw it.
Okay. All right.
Well,
Judge, we've moved to introduce it for whatever relevance the court may take it.
well, and Your Honor, we argue that it's not relevant at all. There's no evidence it's directed to her. The evidence in front of the court is this is an account that's posted for lots of people to look at. There's no evidence that Ms. Scarborough created this. People repost things all the time that they think are humorous, and therefore I would argue it's not relevant at all.
Well, she's identified it as something that has come from the respondent. I'm going to allow it over your objection, and once again, giving it the appropriate weight. And it certainly can be argued there's a broad view of an exhibit like that. But I'll accept it. What's the number?
We up to 9 or 10?
9.
Nine.
I'm going to hand that up to the judge.
All right, Over the objection.
I will hand the previous exhibits back to the court as well.
Okay, thank you.
That were not introduced, I understand.
That's correct.
Okay.
After you got the, I'm going to go a little bit after the protective order, and then we'll go back right to the end of May when you got the protective order. After you got the protective order, what happened to the Tyrant Hunter account online, if you know?
Well, I would object to any evidence of what happened after the protective order, because this protective order, by the language on the order, has always been continued relating back. So anything that's happened since the protective order, unless they can argue that it is a threat, violence, or force, I would say it's not relevant.
Well, there has to be some link to a threat.
Okay. There,
Not sustained objection as we are now.
give me just a second.
Your Honor, the evidence that's proffered is that the Dropbox and the Tyrant Hunter account went down after that. I would argue that really isn't relevant either. I don't think they've introduced anything to this point that goes to threat, force, or violence as contemplated by the statute, but for what weight it bears, I'm fine with the court considering that.
Well, that they are down now in and of itself is relevant just because they were things that were part of the complaint in the first
Right.
place. So for that purpose that they're now down, I'll allow it, if nothing else, as a mitigation of whatever the situation is.
And I just want to remind the court that there was the protective order language that said she couldn't communicate like this. So it's as likely that they're down to honor the court's order as because,
Sure. That falls within, just because they come into evidence doesn't mean they're limited to only one argument to it.
Yes, Your
what they
Honor.
mean.
Yes, Your Honor.
Are you able to, with the Dropbox, were you able to see about how many individuals had viewed? Does social media keep track of that information?
Yes, there was like a Dropbox where you could click on each video posting, and then there was like a Dropbox that allowed you to see how many views total.
Okay. And how many views were there that you could see?
That I could see before it was
Taken down.
deactivated or whatever. It was roughly like 20,000.
Objection to foundation. I mean, other than she's claiming she saw something in the Dropbox that had 20,000, but there's no evidence that that's accurate.
Well, that's her assessment. You can cross-examine her on it.
That's not the
I'll allow
Dropbox,
it.
is it?
Come on. Objection overruled.
That's not the Dropbox. That's YouTube.
As you got closer into in May, just prior to requesting the protective order, what other things occurred, as best you recall, that were concerning to you regarding Ms. Scarborough?
Going into May,
Yes, ma'am.
the continuation of social media posts on various multiple platforms, continual every single day, just about, as I mentioned. There were, some community meetings that I had typically been going to, that Ms. Scarborough was in attendance as well at those meetings, and my analysis of all of the social media posts and the feelings that were being conveyed through those social media posts made me not go to some of those meetings at all.
Okay.
Objection, relevance.
We're going to come back to that.
All right.
At some point in time in May, you went and sought a protective order. Is that right? A preliminary protective order?
Yes, sir.
Is that the copy of the protective order that you received?
Yes, sir.
In there,
Objection to any leading.
Excuse me?
Objection to any leading, I was going to say.
Well, he can ask her to identify
Right.
the protective order. The court can take judicial notice of that.
that's protective order.
Yes, sir.
In there, the judge made a comment about threats. What kind of threat?
I'm an object. Well, I'll withdraw it.
What kind of representations did you make about threats to the judge in order to get a preliminary protective order that you have not mentioned already?
Well, I recall before the relationship soured, I recall many conversations with Ms. Scarborough that she relayed her disdain for.
Objection, relevance. This isn't even about Miss Bellido. It's about somebody else.
It has to be about her. I'll sustain that objection. Unless it's
Yeah.
a threat to her.
What other threats were you concerned about that you thought were directed at you or could be directed at you?
Well, at this point in time, I had become part of. I had become affiliates with people that she had, or groupings that with people that she had previously expressed.
Objection to hearsay.
Well, I'll let her say
What Christina said.
What the respondent said.
Yeah, you can't say what anybody else said. You can tell the court what Ms. Scarborough said to you.
Well, she had previously told me that her vision was to take out anybody who was part of groupings or political affiliates who.
Well, object. It's not about Miss Bellido. This is about somebody else, and it's just general language. Take out. It could mean anything.
Well, that's true. If her basis of fear or some sort of threat or force maybe being exercised against her is based on her statements to her about other people that she was threatening or menacing, I will allow that if that lit some fire of concern over her, and apparently that's what appears to be what the situation was as described to Judge Daniel, which is what the question was. What was the testimony to the court for the preliminary protective order about threats or fear or violence? So I'm going to allow your objections open.
And was there a photograph that went along with that that gave you concern with Ms. Scarborough in it?
I'm sorry, could you repeat?
Sure. Was there a photograph that gave you any concern about what she had put up that you felt might be directed towards you?
On the Twitter,
I'm going to object to best evidence and authentication. If we don't have it.
To the extent that would require evidentiary proof, I think he's right. Objection sustained.
You started to earlier. What was the I'll take that back. You indicated that you have had some what I would describe as emotional duress or fear for your safety in the last several months. subject to counsel objecting to me leading, is it fair to say what has transpired, say, since March until now that you have had to do to, what changes have you had to make?
Objection, this isn't like some sort of damages portion of a trial. I mean, we're determining whether the statute has been met, not the impact to her.
How does this
Judge,
impact whether to grant a protective order?
I think it goes to whether or not she places her in reasonable fear for her safety, causes any emotional distress. We've already established a pattern of willful conduct by Ms. Scarborough from early March through late May. I think she can testify about what her concerns are, and then if the court wants to tailor those into a protective order, you can.
Anything further?
Yes, Your Honor, it does not meet the standard of the protective order. And her reasonable fear would be something the court would determine by looking at the evidence. And, moreover, reasonable fear is not in 152.9 paragraph D. That's not something the court determines. The court determines if there was violence, force, or threat. And I would argue the reason the legislature has so crafted the statute is because it is an extraordinary remedy.
Okay, I agree with that. I would sustain the objection.
If the court were to grant a protective order in this case, what would you like for it to say?
Objection, I think.
Is it fair to say you don't want her to have any communication directly with you?
Well, I'm going to object. I think that would be relevant maybe after the decision whether to issue a protective order or not.
Yeah, I think that would come if the court determines that the elements of the statute have been met, then there are conditions that can be considered in furtherance of that decision, but that's the threshold for the decision.
Yes, sir. The protective order was issued around the same time that the criminal charges were issued, is that correct?
The protective order was issued, and then I believe it was about 6 days later, there was another social media post that was brought
Well,
to
I'm going to object. This involves a case that was dismissed and it's not relevant.
Well,
A case that was dropped, actually.
right, it may be, but the criminal case was brought after the protective order or before the protective order.
I think she's talking about another criminal case that the prosecution elected to drop because of total lack of evidence. And therefore, I think it's a total red herring.
I was just trying to get in that there was a criminal charge that arose out of these things at or about the same time as the protective
Oh,
order
well,
issue.
but there was a criminal charge.
There was a criminal charge. It's since been dismissed.
You're right, but that was after the preliminary protective order was entered, wasn't it?
Let me check. Yeah, the criminal, I believe, came first, Your Honor, and then the protective. The criminal charge was, the criminal charge offense date was February 1st, way before the protective order. And let me see when it was actually served.
I think the dates were inclusive. I thought it was February 1st to around May the 18th.
Yes, and it was issued February 18th, 2 days before the protective order was issued.
May the 18th.
May the 18th.
Okay.
Okay, well, that would have been relevant if we were looking at a mistake by the judge.
Right.
Okay, all right.
Is that fair to say those dates that we gave you, that the criminal charges were around the 18th or so of May, and the preliminary protective order was issued around the 20th of May? That sound about right?
I believe so.
Okay. Is there any other act of violence, force, or threat of criminal offenses directed towards you that you haven't already testified about today involving Ms. Scarborough?
Just as I previously mentioned, multiple social media posts on various platforms that every day have been directed towards me, as I previously mentioned, by name or referring to the injunction that was in progress.
Okay. I don't have any further questions, Judge. We would reserve the right to put on evidence at a later time if necessary about what she has had to do or any counseling, medical issues, safety concerns around her house. We would reserve the right to do that.
Okay, cross-examination.
Thank you.
Does anybody need a break yet?
Not me.
I'd like to
Good.
finish with this witness, we might take a break then. Okay,
Thank you.
cross-examination.
Miss Bellido, just to recap a little bit, this relationship between you and Miss Scarborough originally started right around the time that you wanted to sue the Frederick County School Board for their mask mandate, correct?
No, it goes back a little bit further, maybe October, no, towards the end of like the campaign season.
Okay.
That's when I first met her.
But you all talked about this suit against Frederick County School Board for the mask mandate.
We did.
Okay.
Yes, sir.
And I remember your testimony from last time. You actually wrote the lawsuit.
Yes, sir.
And you gave it to Mr. Griffin's office to type up and file?
Yes, sir.
Okay, or did you type it up?
I typed it. And then he filed it.
All right. Now, you knew when you would file the suit for the mask mandate, this would be something that would be interesting to more than just you, Miss Scarborough, and the other people involved in the suit, correct?
I think that's correct.
In fact, it was in the newspaper, wasn't it?
Yes, sir.
And originally, you all were friends. You and Miss Scarborough were friends.
Friendly. Yes, sir.
Friendly.
Absolutely.
And the animosity didn't start until after she asked to be removed from the lawsuit, correct?
No, sir, that's not correct.
When did the animosity start?
On February 27th, I believe, Ms. Scarborough requested through text message a copy of the school district's response, which, because she said she was going to file her own motion to dismiss or motion to whatever that's called. She said she was going to file her own. So I sent her a copy of it via text message. I also have paper copies available as well. And we exchanged some conversations thereafter. We were gonna actually have like a play date between her son and my children, which had been scheduled, but I had to cancel that. So we continued some communications thereafter. I stopped communicating with Ms. Scarborough when her text messages I will say earlier, when her text messages were conveying, when her text messages started conveying angry and allegations, then I just stopped all communications at that point.
Now, you testified you contacted the Frederick County Sheriff's Office several times.
Yes, sir.
All right. And one of your contacts was a phone call with Deputy Tanner, correct?
I don't know. I don't know that I asked for names every time.
Well, when you spoke to these deputies, they asked you if there were any threats being made, any threatening messages. Is that correct?
I don't recall, sir.
All right. Well, do you recall a statement you made to one of the deputies that I haven't received any, like, threatening messages?
That's correct, sir.
Okay. And would it make sense that that statement was made a few days before the protective order was issued?
I'm not answered concerns
Okay.
to dates.
Okay. But as of a few days before the protective order was issued, that's a true statement. You hadn't received any threatening messages.
I hadn't been told that I was going to be killed or hurt or maimed,
All right.
any of that.
But that was a true statement that you would have told the deputies.
Yes, sir, absolutely.
And between the time you told the deputy that and you got the protective order, there were no threatening messages sent, correct?
As defined as being killed, told I'm going to be killed or hurt or something, or maimed, or, the magistrate in March, the female magistrate at the jail,
The one that would not issue the protective order?
yes, sir, she asked me actually those things. Have you been threatened, have you been threatened to be killed or hurt yet? And I have not.
How many times did you go to the magistrate for the protective order?
I went to that female in March, and then in May to on May 26th, I believe.
So twice?
Yes, sir.
These might sound like stupid questions, but Ms. Scarborough has never attacked you physically,
No,
correct?
sir.
All right. She never tried to use any weapon against you.
No, sir.
All right. Never gone after you with her car.
No, sir.
Never applied any force against you personally. Physical force.
No, sir.
Court's indulgence. No further questions. Thank you, ma'am.
Redirect.
Mr. Bassler asked you if you went to the magistrate and you thought it was around May the 26th. The court order would have been assigned on May the approach. The court order was signed on May the 20th. Do you think you went to the magistrate's office before May the 26th?
It could have been. There's been so much transpire in the last 6 or 7 months that some dates stand out more than others. I'm sorry, I don't recall all of.
And I understood it to be approximate date, Your Honor.
Okay. Mr. Bassler asked you about any text messages that were angry, making allegations.
I didn't ask that.
I'm sorry, that was your answer in response to one of his questions. Are you referring to any additional text messages, or is it the ones that you previously testified about today?
I believe I was referencing when our relationship ceased. Those text messages that I received, those were alleging forgery and fraudulent acts. And that's when our communications at that point in time completely ceased. I did not engage any further with Ms. Scarborough even to this
Did
day.
you block her at that point in time, or did you just stop communicating with her?
I stopped any further communications at all.
And after she made these claims, did she follow up and have any additional statements, comments, text messages to you?
I would object is outside the scope of cross-examination.
I'm going to allow it. It sort of is within the scope, but I'm going to allow it.
I'm sorry, do you
Sure.
repeat that?
After you ignored her when she made these allegations, did she respond to you with any other follow-up? Or did the communication, you all just stopped and nobody blocked each other?
I don't know if she did on her end.
Okay, you didn't block her.
No.
And when roughly was that breakdown in communication in relation to the trespass notice or the cease and desist letter?
I believe those text messages came to me, I'm pretty sure it was February 25th to February 27th.
Okay.
Again, I'm sorry, I don't remember
It's okay.
every date. there was a community celebration that we had put together that took place on March the 5th or March the 4th. And there had been no communication in that week or so between Ms. Scarborough and I at all. I didn't respond to those text messages. And she made a posting on the community forum regarding that celebration. She previously told me that she wasn't going to be able to come to
Objection, not responsive to the question.
Yeah. I don't have any additional questions.
All right.
Thank
You
you.
may have a seat back by your attorney now.
Judge, I would,
Yeah. But,
that's our copy of
Right.
it. I'll take that back. Thank you, Judge.
thank you.
I would concur that a 5-minute recess.
All right, we'll take, we will reconvene at 20 of 11. 20 of 11.
All rise.
And I'm just going to tell my client, Your Honor, she can't talk with the witnesses
Yeah,
about the
right,
case.
right. Okay, thank you.
Court in recess.
Anything else that you can think of?
You guys are done.
They were out in the hallway. It might be one of the side doors.
Up in 3C, which one?
I know that they
Okay, yeah, I'll do that.
Yes, they're gonna make administrative
Hi, Bob.
posts on the Facebook page. And
I'm
they
good.
have the health administrator
Hi, Bob.
jobs. Just them and her.
Yeah.
I'm privy to those.
I'm gonna ask them that if they don't, because it looks like the judge is there.
Yeah. But, no, he's a duty with Judge Alfred.
Oh, gotcha.
I gotta run downstairs, I gotta read the call. I didn't realize you suck in there. I gotta run down here, so it works on. All right, that works.
What's the other one, Jennifer Adams?
Ariana.
Okay.
All rise. Chair, District Court's back in session.
Thank you. You may be seated. All right, Mr. Griffin, next witness.
Judge, I've conferred with counsel. There are two witnesses out in the hallway that both testified last time, Jennifer Adams and Ariana Tehran. They testified in the criminal proceeding. I understand the court's ruling is that essentially we would recognize whatever they testified previously, and they just testified basically identifying the Twitter account. They do not have any additional, and my proffer would be to incorporate their prior testimony. My further proffer would be that they don't have any separate specific knowledge of Christina Scarborough making acts of violence or claims of violence, force, or threats directed towards Priscilla, separate from what the court's already heard.
Okay.
Does that make sense? Did I say that right, Beth?
Fairly summarize your understanding?
Yes, I mean, my recollection of their testimony is they testified about the Dropbox and social media,
Right.
Twitter. But my objection was just understanding that the court can consider that, just like it can consider all evidence, and my objection would be it's not relevant. And I think that can go more or less to argument.
All right.
It's nothing new. It's nothing we haven't heard
All right.
already today.
Do you have any other witnesses?
With that we would rest our case, Judge. That would conclude our evidence.
Okay. That's the petitioner's case.
And Your Honor, we're prepared to just move forward to argument
Okay.
on the case. We
That's fine.
think we're there.
Yeah,
So
good.
I know they have the burden, so I will defer to them.
Okay?
Judge, on the issue here, talking about prohibiting acts of violence, force, or threats of criminal offenses that may result in injury to person or property. These two parties were pals for a couple of months, October, November, December, joined forces in a lawsuit in late January, early February, and then things went haywire and they went downhill in a hurry. And they seemed to escalate pretty quickly, which I think is concerning. Is there any specific direct claim of violence or actual violence directed at Priscilla? No, there's not. But it starts out in February. She's accused of forging signatures. The last time we heard the term stacking bodies was used. On March the 9th,
I don't think that was in evidence, stacking bodies.
on March the 9th, there was a text communication between these two where Priscilla was called an effing idiot, an effing dumbass, and 2 hours later had somebody show up at her house. She decides, what do I do? In the next 2 months, she calls the Frederick County Sheriff's Department 4 times to try to make sure that she and her family, her two children, and her husband are safe. On March the 14th, she has a trespass notice. That would be the next logical step. She's had Christine over to her house. She has her served with a trespass notice. That apparently didn't scare her off enough. Apparently it went viral. March the 17th, there's a cease and desist letter. The police stopped talking about me on a regular basis. And apparently all that did was amp things up. Ms. Bellido's testimony is that basically every day on multiple occasions per day, Ms. Scarborough would post something on social media, mostly on the Tyrant Hunter page, about Ms. Bellido. She would say stuff like, All she did was piss me off, not shut me up. I barely scratched the surface, sweetie. I'm putting a smile on my face and your crap on blast. A couple days later, we see that April 2nd, I identify as a threat. Try me on the Tyrant Hunter.
Right.
She made efforts to post pictures over a 15-year or so period of time of Ms. Bellido, where she worked previously, pictures of her family, her email address, her telephone, her physical address, and I understand the court's ruling in the criminal case. Things apparently didn't get any better. When all of that didn't work, even though Ms. Scarborough claims that Priscilla became unhinged, she's now a snowflake. She says, I'm going to put all this stuff in a Dropbox. And she did. She put what appear to be hundreds of items in a Dropbox, not with any limitations, for anybody to see. Apparently, almost 20,000 people have looked into this Dropbox in the last 2 or 3 months, as best we can tell. The Dropbox is now gone, but that was the testimony. Finally, she says, well, I contacted the magistrate at one point, I then contacted him again, and I got a protective order. This account on Twitter is now shut down, the Dropbox is now shut down, and the only other language that was out there is Ms. Bellido, in addition to being concerned that Christina identifies as a threat, relays that back to people being taken out. And so she came and she sought a preliminary protective order, which the court granted. And we would ask the court at this point to extend it as a permanent protective order. That there is and has been evidence of a direct and indirect communications intending to put Ms. Bellido in fear, to intimidate her, using phrases such as take out. She's concerned for the safety of her and of her children, and the court required that the respondent stay at least 500 feet away from her residence, not make any social media posts or
Objection to
comments.
what the court, he's not arguing the evidence. The prior order is not the evidence.
I think the prior order was pretty reasonable, and we would ask that the court use that as the basis, and we would have additional testimony should the court so desire to hear it. Thank you.
Okay, thank you, Mr. Brown.
Your Honor, this is like all haystack, no needle, okay? They throw everything at you. They just like, okay, well, let's try this, let's try this, let's try this. Let's see if anything sticks. That's not what the protective order is for. I mean, a lot of people want to water down, inflate out the value of these protective orders. A lot of people want them against their neighbors they don't get along with. Or want them against ex-friends they don't get along with. Okay? This is not everybody come into court, get your protective order because somebody hurt your feelings. Come in, get your protective order because you didn't like what you saw on social media. The statute is clear. Mr. Griffin cites language that's not in the statute. He's given several different standards of evidence, reasonable apprehension of fear. That's not in the statute. He's conflating different code sections, stalking, things like that have that language, and just making this amalgamation of really nothing. Because the statute's clear, and this is the great thing, is all we have to do is open the code section. And yes, the statute's kind of long. I hate long statutes. I think they write them too long. But the part that really matters is paragraph D of 19.2, 152.9. It's very short. It's very clear. And it says, within a reasonable period of time, subjected to an act of violence, force, or threat. Okay, let's step through them. Violence, definitely not. That's Miss Bellido. Force, definitely not. That's Miss Bellido. Threat, okay, maybe a little more subjective. They try to hang their hat on just the thinnest of thin, somebody posting something online. I identify as a threat. My pronouns are try/me, which is clearly an attempt at a joke. Okay? It's clearly a comment on our current social political situation right now with gender identity. It's not directed to Miss Bellido. There was no evidence that it was directed at Miss Bellido. And that, which is nothing, is kind of their greatest hits. With these cases, I would argue that if it's a good petition for a protective order, you can articulate that very clearly in an open statement. Here's the violence, here's the force, here's the threat. We've all seen ones that are no-brainers, okay? Because there are people out there that are violent, that are forceful, that are very threatening. And these protective orders do have a very important purpose. The problem is people want to stretch it. They want to use this protective order as a tool when they feel like they're being disrespected, insulted, upset about things said online. And that's exactly what they're not for. Because the legislature, you know, they're experts at language. Maybe not the legislators, but the ones they have working for them. They can draft something, gets right to the issue. And they had a lot of words to choose from, but they chose some very, very powerful ones. Violence, force, threat. We don't have any evidence of that. Putting your quote-unquote crap on blast, maybe it's not the best practice to say things like that. Maybe it's not even civil discourse. I think intelligent minds could differ on that. But one thing that's clear, it's not a threat. It's not violence. It's not force. And Mr. Griffin mentioned a few things in passing I want to address. He said someone came over to Miss Bellido's house. Well, that's all the evidence we had. Someone that knew Miss Scarborough came over to her house. There was no evidence about what was said at the house, what was done at the house, other than somebody came over to her house. It's as likely as not that was just an innocent encounter. 20,000 people viewed the Dropbox. Well, that was objected to, and Mr. Griffin tried to introduce something that was actually a YouTube counter. And so I would argue that that's, even if there was 20,000 people that viewed the Dropbox, that doesn't go to whether there was a threat, violence, or force. That goes to what brings us here today, that Miss Bellido is very, very upset about this. She doesn't like it, and therefore the tool that she's tried to use between her and her attorney is the wrong one, the protective order. And I respectfully request the court to dismiss this case about Miss Scarborough. She's had the protective order, in my argument, far too long, Your Honor. Thank you.
Thank you, Mr. Pastor. Mr. Griffin, any further?
Just briefly, the threats issues, I think, are laid out. She accused her of crimes. She used the F-bomb on a number of occasions. She said language about being taken out, stacking bodies, and posting pictures saying, I identify as a threat. All we can do is take her at her word. She individually identifies herself as a threat after a course of conduct and a history from February until the time that she posted this, until a protective order went into place, badgering, cyber harassing, cyber stalking Ms. Bellido, and she did everything that she could before getting a protective order. She sent out the no trespass notice, the cease and desist letter, tried contacting the sheriff to see if they could make it stop somehow, and when none of that worked and things got amped up, and again, we take her at her word. All she did was piss me off, not shut me up. I barely scratched the surface. How is that not taken but as by anything except as a threat? We think a protective order is warranted based on that language.
The perhaps most significant aspect of this situation is how voluminous the communications became after the relationship went in the tanks. And there was a lot of annoying conduct by the respondent to the petitioner, the court would surmise that she felt some justification in voicing this communication, this objection to what she thought about Ms. Bellido. But the test is as recited by a particular code section, which is designed in a way to have a precision to the transgressions under that code section. And the remedy that the petitioner sought, through some exasperation with the failure of other methods that she attempted without success, was to pursue a protective order. And as unfortunate as the communications may have been, there still is a strict requirement, at least by a preponderance of the evidence, that the requirements have been satisfied by sufficient and competent evidence that there was force, or there was a threat, or that there was violence. And while there was a significant quantity of unwanted communications, all of those communications would fall under the radar of that code section. And it's, as the court started out by saying, it's unfortunate that this dispute escalated into a public strife. But the remedy available under a permanent protective order is simply not there by evidence, and the request for a protective order on a permanent basis is denied. Still on your motion about the preliminary protective order, I have an order that I've entered that it basically denies your relief. I do mention that while the court may have checked the wrong box as to a warrant under 19.2-152.7:1, the intent of the court to enter the preliminary protective order was manifested in the totality of the order. I'm letting it stand. So this is the final order here today, both as to your motion to dismiss the preliminary protective order and as to your request for a preliminary protective order.
Yes, sir. Both sides had, go ahead.
Conclude our section.
Both sides had 10 days to appeal, was that correct?
Yes, sir. It has to be processed through the court.
Yes, sir.
Clerk's office.
Your Honor, on the issue of attorney's fees, which is governed by that statute, Mr. Griffin cited 152.10, would the court entertain a request for attorney's fees in this case?
I'm not going to get into the attorney's fees. I don't think the petitioner was in bad faith. I think she just was at wit's end with how to deal with this. She'd gone through the sheriff's department, she'd gone to the magistrate, she'd gone to the clerk's offices. I don't see a vendetta as much as just looking for remedies to stop this contention. And I'm not going to be granting attorney's fees. I'll follow the American rule. Each person pays their own attorney's fees.
Yes, sir.
Thank you very much.
Thank you,
That
Judge.
concludes our session. And the bailiff can take this down to the clerk's office, and you can get copies of the orders. It'll be this order on top, and then yeah, I guess we have to serve the
But they both have to be served.
denial.
Yeah.
Yeah, so they should take care of that,
Okay.
and then get.
I want us to wait up here on the third floor. So, you want us to come,
Take them down.
you want us to come down to the clerk's office, first floor?